Hi, my name's Mark Troutman. I'm an attorney with the law firm of Isaac Brandt, Ledman, and Teeter, and I'm here today to continue my series of video blogs on public records. Now, today's case doesn't even come from the state of Ohio. It comes from the state of Washington. The case is O'Neill v. City of Shoreline, and for those practitioners or those who have access to Westlaw, the case citation is 2010 Westlaw 3911347. This case was decided less than 1 month ago, but it was only the second case in the nation that handled whether metadata constitutes a public record. Now, in the O'Neill case, Mrs. O'Neill was a person who a public office holder claimed sent an email to an employee of the public office when Mrs. O'Neill actually hadn't sent that email. In order to get to the bottom of it, she made a public records request for that email, and she wanted all the metadata because she wanted to know who sent the original email, because the to and from areas had been blocked off. Now, it's very interesting when applying other states' public records law to Ohio's, because these are state laws, thus they're very specific state to state. However, I at least believe that the state of Washington's public records law is sufficiently similar to the state of Ohio's so that metadata likely constitutes a public record under Ohio law. Then ultimately the court gave access to the public office holder's home computer. Now, if you look at the State ex rel Glasgow v. Jones case in the state of Ohio, there would be similar authority to do that in Ohio, because we know if public office holders are doing public business on personal or private computers, it nonetheless makes it so that the computer is accessible to gather whatever public information is retained on the computer. So then the court didn't ultimately find against the city, but it merely said the city had to go through the cost and burden necessary to look through the computer. This is very similar to the State ex rel Toledo Blade v. Seneca County Commissioner's case in Ohio, where the Ohio Supreme Court ordered Seneca County to hire a forensic expert to look for a slew of emails that it claimed had been lost. Finally, the court held that public entities need not interpret just any request for emails to include those for metadata, but rather a requester needs to specifically request metadata in order to make the public office have the burden of looking for it. Now, you might be asking yourself, okay, well, metadata is a public record. How do we possibly retain all the metadata that our public office likely retains on our computers? The way you handle this is addressing it appropriately through your records retention schedule. As the November 2010 Public Records Press, a publication that we put out here at Isaac Brandt, as that version of the Public Records Press discussed, regular updates to your records retention schedule are key. That means when you read about a case like this or hear about a case like this, you should go to your records retention schedule and see whether it deals with metadata and tells you how and when you're able to destroy metadata. If it doesn't, you should call someone. Feel free to give us a call. Again, my name is Mark Troutman. My number is 614-221-2121, and hopefully we can help you come up with some reasonable solutions on how to deal with this and other situations that could arise in public records law. Thank you.